Well, several people in the cannabis community have found themselves at a bit of a crossroads following President Cyril Ramaphosa's signing of the Cannabis for Private Purposes Bill. The bill, which removes the use of cannabis from the Drugs and Trafficking Act, aims to decriminalise the possession and use of cannabis, let's call it dacha, shall we, for private purposes. While the move was hailed as a step forward by some others in the cannabis users community, are gearing up to challenge the constitutionality of the new law. They say it's not inclusive. News from Africa reporter Msipi Sama investigates.
Signed at the 11th hour ahead of the 2024 general elections, the Cannabis for Private Purpose Bill has now been gazetted, a move welcomed by the industry who say it was about time.
After 6 long years, we finally got him to put pen to paper, and even though this is only a small victory, we definitely have the potential to create those 100,000 jobs that you spoke of in Sona. The cannabis industry is large, and as long as we have the full inclusion of everybody involved, I do believe we can make a huge impact, not only in this country, but make it a benchmark for the rest of the world.
However, not everyone is celebrating, and as the dust settles, some have labelled the bill as nothing more than a smokescreen.
The biggest pointer towards unconstitutionality, in my view, lies in the title of this bill. It's called the Cannabis for Private Purposes Bill, and that is a contradiction in terms, because we were supposed to have had a cannabis bill that takes care of all of the constitutional guarantees in our Bill of Rights, not just privacy. So the next step for the cannabis community is now to challenge the constitutionality of the bill that was just passed into law by the president. And for that, we would have to approach the courts again. And because we are arguing that both the president and parliament failed in their constitutional duties, we would have to approach the constitutional court, the highest court in the land, in order to have this law declared unconstitutional, which then would mean that we would have to go back to the National Assembly, and the public participation process would have to start afresh and anew. And this is rather unfortunate because it has taken us 6 years to come to this point.
Michael Dupree, who has been in the hemp and cannabis industry for 2 years, shares similar concerns. While acknowledging the potential positive impact of the bill on his business, he believes that it falls short of being inclusive and leaves many grey areas and unanswered questions.
Maybe it needs more changes, like a lot more changes, and it might need a complete total reform eventually. But this was the first step to bring something about, and now there is a platform to discuss the things on that needed to be discussed. So we can see that the minister still has to make a lot of those regulations clear to us so that we can all understand. And I think this is also what leads to a bit of public opinion about the SAPS at the moment, which is not positive. And that's because as much as the directive for us is unclear about how much we can have and own and consume, the same thing is for them. The whole landmark ruling was in order to open up the cannabis as a cash crop and have it completely unregulated and have the trade happen all the way from Mpondoland to Kimberley to Bloemfontein and revolve the economy in this country.
For Newsroom Africa on Channel 405, I'm Msipi Sama in Cape Town.
Okay, good morning, Etienne. Thank you so much for joining us here today. Today we are going to discuss the Cannabis for Private Purposes Bill, which has recently been signed into law by President on June the 3rd, if I'm correct. And the purpose of this online meeting is just to discuss the bill and see what it means and get some context behind that. So thank you very much for joining us. We're going to go through a couple of questions. First things first, let's just get to know you a little bit better. Would you mind giving a brief introduction of yourself to our viewers?
Yeah, sure. And thank you for hosting me today. And let's see what we can do in terms of illuminating the act a little bit. So my name is Etienne van Zyl, and I'm an academically trained social anthropologist, but I also work as a strategy and development consultant. So last year I worked as an independent contract consultant on the DTIC cannabis and hemp sector study that focused on understanding demand through a situational analysis and to develop a country competitive strategy that will help guide industrialization of the sector. So the job generally entails infrastructure, feasibility and development studies, the development of economic potential of industrial and logistics infrastructure. So I know this sounds very corporate, but being grounded in the anthropological discipline means I try and focus research and recommendations of these studies on economic development perspectives that serve community empowerment as far as possible. And then within the cannabis space, I wear many hats: academic, researcher, consultant, advocate, and obviously long-time consumer of cannabis.
Okay, lovely. Thank you. So you'll be able to give us some beautiful insights and have a kind of a better understanding of the bill, be able to interpret it nicely for us. I'm just going to get the bill in front of us. Then we're going to start off with just sort of the key highlights of the bill and just run through that. So let me just quickly open it up here on my screen. As we just mentioned, it was published in the Government Gazette on the 3rd of June. And here on the first page, it gives us a nice little overview on what this bill entails. So this bill is an act to respect the right to privacy of an adult person to use or possess cannabis, to regulate the use or possession of cannabis by an adult person, to provide for an alternative manner by which to address the issue of the prohibited use, possession of, or dealing in cannabis by children with due regard to the best interest of the child, prohibit the dealing in cannabis, provide for the expungement of criminal records of persons convicted of possession or use of cannabis or dealing in cannabis on the basis of presumption, and amend provisions of certain laws and provide for matters connected therewith. So, we're just there's quite a lot of things there, but we're just going to go through them one by one. I think a good place to start would be just to once again go through one or two of these definitions. Firstly, the definition of cannabis. What we found very interesting is that here they say cannabis means the flowering or fruiting tops of a cannabis plant and includes products made therefrom, but excludes any seed, seedling, the stalk, leaves, and branches. So, do you just want to give some comment around that? Because it seems like they, once again, splitting the cannabis plant into, it's as if they separate hemp and cannabis. So cannabis is exclusively only the fruit or flowering tops of the plant. Do you want to just give us some feedback on that?
Yeah, sure. So it's a very interesting interpretation, I find, and I think it's quite extraordinary that we got away with that language in the bill, because it does allow for enabling a lot, even though it's not perfect, and it does, create some interesting contradictions. In terms of the definitions, they're definitely much less restrictive. But there is this ontological irony, of the chosen lexica and its implications, which are not lost on me, and I'm sure many taxonomists and horticulturalists kind of feel the same, and are probably having a good chuckle, about this. I know I am, but that's the nature of law and trying to legislate the space for this. So it means kind of that cannabis is not cannabis, it's only, according to the Act in any way, only the fruiting or flowering tops would be regarded as cannabis, whereas the whole plant, anything from the seed to, up until a point where it starts showing any kind of flower, would not be regarded as cannabis, but it does open up quite a bit of possibility, like I said, which means, it allows for a hemp industry to go online pretty much since the Act was assented. And, for other national policies to kind of dovetail into provisions within the Act to allow for, commercial activities and so on, which we haven't seen yet, but they are in the works.
You say it is, in a sense, quite a beneficial thing, because that means it's less restrictive, because in terms of this bill, it only gets regulated from flower. The rest of the plant is kind of irrelevant in terms of this bill.
Yeah, for sure. And that's why it essentially assists whoever wants to invest in any kind of or undertake any kind of industrial cannabis operation to cultivate. So you can cultivate anything as long as you harvest before the plant starts flowering, which for fiber purposes obviously means, you can do that for herd, for cell fluid, maybe of particular kinds, depending on, maturity of the plant and how, the biochemical composition changes. But I mean, it does problematize seed, because obviously you need flowers to produce seed, even if you do use that seed for either saving it for, the next planting season, or for food stuff, or whatever other industrial purpose. So there are some limitations, but there are also national policies and so on that do enable those sorts of operations through permits or licenses and so on.
Okay. So now with the Cannabis for Private Purposes Bill, like our club here in Plettenberg Bay, the Canna Club, its operations are all based on the Cannabis for Private Purposes Bill, and it aims to fall within that legislative framework, right? In terms of that, I just want to read one or two more definitions here, which is relevant to that. And then you can once again just kind of give your feedback on that. Here on page 4. So under the definition deal in. So deal in is obviously a big one, because there's big criminal offenses linked to that. You can get some serious discourse. You can get up to a 10-year prison fine, or you can get up to a 10-year prison sentence or a hefty fine. So it's just to understand that and see what sort of legitimacy private cannabis clubs has in correlation to this bill. So deal in means to provide for consideration, receive for consideration, sell, buy, offer for sale, offer to purchase, import, advertise for sale, export, cultivate for the purpose of dealing, and any other conduct to facilitate the selling of cannabis, but does not include any such activity that is authorized in terms of this act, or in terms of a permit or license issued under any other national legislation. So that's quite an interesting one, because I know with our model, when a member signs up at the club, they give us permission to cultivate one tree on their behalf in flowering at any stage, and then it goes towards a collective member stockfell. And then when the member withdraws from the stockfell, they reimburse us for the plant management fees, which get dispersed to various service providers, like the cultivators, the processing and packaging, the clubhouse management. So in essence, the member is reimbursing the club for the plant management services and not the cannabis itself, which is a very interesting one there. Anything you want to say around that, or give us some insight around that, your perspective?
Yeah, so thanks for your your clarity on how your model works in that regard. And I'll start off by saying that firstly, I'm not a lawyer. I do work in the policy space, so I am familiar with the legalese around this. But yeah, it really depends on your club model, and not every club model is equal. So I would say, firstly, just broadly speaking, in terms of cannabis clubs, it really depends on the definitions in your constitution. But understanding obviously how your model works, I think it's, in my opinion, again, one of the better models out there because of its community focus. And many club operators I've met are obviously more in it for the money, trying to capitalize on the so-called green rush. Where your model is definitely community focused, with the aim to empower and uplift. So departing from that point, in terms of how we interpret the so-called gray area that exists still within the Act and the broader legislation, it's a tricky one, and I would say that it needs to be tested in court before one could ever clearly say, obviously yes or no. So it kind of needs the state's stamp of approval, which is, it's not a nice constraint to function under, because of what the model tries to
still poses a risk.
Facilitate. Yeah, it still poses a risk, But the case again is that ultimately people need to access cannabis in order to exercise their right to use cannabis, right? Which is in part the purpose of the constitutional protections afforded through the 2018 ruling. So I found through my research, for example, that the majority of people that use cannabis do not necessarily possess the means to cultivate their own. For whatever reason, they don't have the knowledge, the skills, the time, the space, whatever, right? So the question remains, where is one supposed to legally access cannabis, for whatever purpose you choose to consume it in private? And I feel that social clubs aim to fill this gap in the most legal way possible, potentially with a number of positive spin-offs as well, like safe sites for access, quality control of products, and so on. Which, I have to caution also, this does not mean that all clubs follow best practice.
Yeah.
And that remains a concern for the state, just to balance it from the other side. But the question here remains monitoring of systemic integrity. So if we can get that right, I think it's a very good framework already, and it's been proven for at least half a decade now that it can function as a self-regulating entity, especially if it's community focused on delivering the service and good product. So yeah, with regards to the legal definitions, it's a tricky one, like I said, but I hope we see a good, useful precedent come out with maybe the Hayes Club, even though I don't feel it's necessarily the best or the strongest case, to test this on, because it's a very different model to what people are employing right now.
Yes.
But it's evolved since then, right? Because it did kind of raise concerns, and people had to double down and figure out how to properly structure their language for this, and to show, hopefully also through recording of data, that this is how it operates, this is the function for which it operates, and this is how we can prove safety and quality of products. So that's about as much as I think I can say on that.
So do you think there will be more clarity and kind of a more of a regulatory framework established within the commercial bill for this sector, like towards clubs and the adult, private adult recreational space? Would that be something that we can expect more in the commercial bill to provide space for?
Well, okay, so just from a basic reading of the news, right, and communications in policy documents and legislative documents like the Act, and what the initial cannabis master plan, which is being updated also by the research done by the DTIC or commissioned by the DTIC in 2023. It points to the fact that there are certain segments within the sector that are definitely being earmarked, that being medicinal and industrial cannabis. And for the obvious reason that there's soft landings, so to speak, right? You don't need to challenge a lot of your political ideology and international, geopolitical considerations or relationships within that, because obviously people still have this, countries have this idea that we function within harsher constraints under the single convention of 1961 and amending or complementary treaties to that. So there's 3 treaties, right? 4 if you count one of the extra amendments to the 71. But we're not really constrained necessarily in terms of that as much as people think, but that's more of a political issue than I would say it's a regulatory one. So it's again, their political will plays into it. But to get back to what I'm trying to say here is it's it's hard to say at this point, but we'll see in terms of national regulations. But there's definitely focus on those 2 segments that make sense for the government and are easy to do. I know that there will be, or at least I've heard that there will be a full Plant Purposes Act, right, or a whole Plant Purposes Act that will be promulgated in the next 2 to 3 years, but it's going to take time. It's going to take civil participation still to show that there is a need for enabling this pathway, because it's at this point it's not really a priority for the government, because there's so many other things they need to consider as well. Cannabis is just one of so many portfolios.
I believe that there's a beautiful space for clubs in South Africa if it's done in the right bona fide way. Right now, nothing is legal per se. No one can give you a bulletproof model that something is legal. But there is a way for people to exercise their constitutional human rights in collectives. And what I'm saying is that can foster a beautiful kind of, like Fields of Green always mention, clubs as a site of harm reduction, of educated, safe adult use, right, which is non-commercial. It's run through a non-commercial, non-profit model where people come together, right, and share and pool resources kind of thing in the bona fide manner. And what I'm saying is that if you look at, instead of looking at jurisdictions like the United States and Canada, for example, where they've kind of leapfrogged over the whole beautiful thing, which is shared culture and consumption culture. It's just, instant gratification of going to the shop. They're lacking that. But if you look at countries maybe like Germany, doing interesting things, in my opinion, they've taken this approach, which is like a two-pillar approach to commercial adult use of cannabis. And the first pillar of that is brilliant. The second pillar is full-scale adult use commercialization, right? But the first pillar looks very much like clubs.
Just going to continue with one or two more of these definitions that I find interesting, like the private place. So this is interesting, especially once again in terms of, the club model, the shared collective model where members collectively cultivate cannabis in a shared communal space. So here under private place, the definition of private place, it means any place including a building, house, room, shed, hut, tent, mobile home, caravan, boat or land, or any portion thereof to which the public does not have access as of right. And this is the interesting part, any part or portion of a communal land as defined in Section 1 of the Communal Lands Right Act 2004, which in terms of the rules or custom of a community or the standard rules contemplated in Section 19 of that act, is a place which is exclusively used to cultivate or use cannabis in a private place by an adult person as a member of such a community. Now that is quite a mouthful and maybe not so simple to just take in, but we kind of interpret that as, that is brought in there where communal land, where people collectively cultivate, is also here defined as a private place, which is a great inclusion, because it creates a little bit more leeway for clubs that run on that way as well.
What's interesting for me specifically is Section 19, 5, of the Act, where it talks about interventions by the minister if there is some sort of issue that needs to be resolved. And I find that because of that trigger in the bill, if disputes of this nature need to be resolved, it holds the potential to bring the case to court, through a legal challenge, where the state then needs to make an argument, and from civil society or whatever, say cannabis club operator or model, you can also set forth a good argument and hopefully set a good precedent by that. So to me, that's pretty much the most useful function I see within that, aside from the definitions that you'll then have to use in your argument. But again, if it's being cultivated for for private use, the plant always belongs to either the member independently or to a pool of members, as in your stokvel model. I think it provides a logical roadmap and framework according to which to interpret it, and it sets a good, well, it makes a good argument, but one that ultimately, like I said before, needs to be tested in court for it to be safely recommended as an approach that's not going to land you in any trouble officially.
For now, it still always remains a risk until we've got proper, clear regulations or a stamp of approval from government side, which says, okay, it's all right for the clubs to operate. For now, we can kind of just make our own interpretations, and do it to the best of our capability to fit within the legal framework, without transgressing any laws or placing any of our members under any legal risk.
Yeah,
Yeah.
something I would add to that is,
Yes.
so regarding the clause that you mentioned, right? So it speaks to sharing in private, right? But one must be careful not to stretch or overly rely on this mechanism, I would say, because the argument does rely, like I said, on legal opinion based on semantics.
Yes.
And what the provision is actually saying, if you read it logically, reasonably within how it's stated and what it tries to facilitate, is what do we want to exploit it for, right? Versus what is defensible in court and worth wagering the infrastructure of an entire supply chain on, and the supply chain being cannabis social clubs, right? So I see this method potentially falling into the same interpretive trap in some ways as the so-called Section 21 dispensaries do.
I see, yeah.
Because if you look at how much is justified per occasion, which is also another definition in the bill, right? In the act, sorry. So, and this can be considered as obviously as member A or member B is cannabis, but I mean, the exchange implies from someone else's private stock and not your own cultivated on behalf of someone else, as most private models currently argue. So I think in that sense, your model is probably still more in the clear, especially if there's this pooled cannabis that you agree to, and it is a communal pool again. So again, it really depends on your definitions, and if you get it right, there's no reason why you cannot successfully argue it and set this precedent,
Yes.
And the the irony is that we're only devising all of these, really tricky sort of trapeze-like arguments because again, social clubs need to fill this gap in the most legal way possible, in order to actually allow people to access cannabis, which is, in my argument, the reason that we had the ruling, the 2018 ruling initially is to provide for consumption without harassment, without it being a criminal offense. And within that, there is this very obvious, part of the situation that we are doing all of this, going to all this effort, arguing it in court, because people consume cannabis, and then the question is, where do they get it? People generally buy this. It's because we know we have to police cannabis, right? Before, so now suddenly it's not like that's going to fall away. And if you, it is a way that the state is in some ways trying to again limit the use of cannabis as it falls under a drug status, so. But that's again because of other national policies like the national drug master plan and other policies within the Department of Social Development, for example. So because the onus is on the state to regulate and maintain order in a certain way, unless we challenge those perspectives, we'll be sitting with the same interpretation of this and that is a drug and this is how we act or intervene in case of what we term is abuse and so on. So it's it's an ideological issue and it's a